Here we go. The Supreme Court has handed former President Donald Trump a loss.
Boy, that's a big loss.
In the dispute with the Justice Department for the documents, over those documents seized from his Mar-a-Lago home and club in Florida. In a brief unsigned order with no dissents noted, the High Court rejected the former president's request that the special master be allowed to review the more than 100 documents marked as classified. The batch is just a small part of the 11,000 records that federal agents seized in August and concerns that Trump unlawfully kept official White House records after he left office. The decision does not affect the Justice Department's access to the same documents as part of its criminal investigation.
All right, so Ken, help us out here with the procedure. This actually, it reminds me, if I were a law student, like they would, this would be a great test.
Right.
So what does this ruling leave in place? What does this ruling push aside? What's the status of the case right now? You have 3 hours.
Oh my goodness.
With pens.
And I'm not a lawyer, so look, it leaves in place the 11th Circuit ruling, which, remember, was the product of a 3-judge panel, 2 of whom were appointed by President Trump, which stayed part of Justice Aileen Cannon's order that put all these documents in front of the special master. What the 11th Circuit said is, in terms of the classified documents, the 100 classified documents, those have no business being reviewed by a special master, and the FBI should immediately get access to them for their criminal investigation.
Right.
So the Trump lawyers took part of that to the Supreme Court. They said, we think the classified documents should be reviewed by the special master. And by the way, if that had happened, you know who else would have gotten the classified documents? Trump and his lawyers. So that was, I think, the real intent of that request. So this is about as strong a rebuke as you can imagine, right? A one-sentence order, not a single justice, not even Clarence Thomas, finding any reason to put any stock in the arguments made by Trump's lawyers. And remember, that was like a 80-page brief full of extraneous arguments, none of which persuaded any single Supreme Court justice.
It's so interesting, Michael. I know somebody who's associated with the 11th Circuit, very conservative circuit. And this person said to me, Trump's the 11th Circuit's going to just knock him down because they're conservative, but they don't put up with, they're going to be really offended by this BS. Just like I did somebody who was connected to a conservative Federalist Society judge in February of 2017 when Trump attacked the Bush appointee for one of the rulings, and just said he doesn't know what he's just done. If you attack the independence of one federal judge, you attack the independence of all federal. And I'm sorry, I understand people are offended by the Roe decision and the overturning, but these people have believed this legally since law school, for the most part. But in these cases, the Supreme Court, 65-0, let stand in place federal judges, Trump judges, not going along with the nonsense. And yesterday, again, in a matter of great import, so something that rose above politics, the court again said, don't bother us with this. We're offended. One sentence, gone.
Well, what it says, and I think very much to Ken's point and yours, is the Aileen Cannons, Judge Cannon, they're the aberration. They're still outside of the mainstream of judicial prudence that you hope and expect from your judges. In other words, they're going to look at the arguments that are presented to them. They're going to weigh those against the facts and the law, as they say, and they're going to rule accordingly. And you're right, the 11th Circuit, it's not, it's not the 9th. It's a conservative circuit. And so I know a lot of folks initially were like, oh my God, this is all going to be Trump lawyers sort of handing him what he wants. And what they did was they stood up the Constitution. They stood up the rule of law. They applied the law to the facts and to the arguments that were being made. And then to Ken's point, they just came back with one sentence and basically said, hell no, go back home. This isn't going to work. And that's good. That's refreshing. Now, I don't know how much more strain the judicial system is going to be able to withstand in the coming months and years. But at least right now, they're holding to the constitutional line.
That's absolutely right. And can I just say, though, that this whole debate about the special master has been a little bit of a sideshow, because while this has been going on, the FBI has been diligently interviewing witnesses about what happened to those classified documents. And this week we learned that they talked to a Trump employee who says he was ordered by Trump to move those documents after the grand jury subpoena came in. So this investigation is very active, very serious, and it goes to questions of obstruction as well as mishandling.
And by the way, I have said time and again, and people after Cannon's ruling were like, "You're wrong, Joe." I've said time and again, the Supreme Court, for the most part, if it doesn't have to do with ideology, if it has to do with things that Donald Trump, when he's trying to push the rule of law, they've held firm. And they're, of those 65 justices or judges, federal judges, I've read some of their rulings to see how conservative they are. They're really conservative, like things that were just. But again, I think what Michael said bears repeating. There are outliers. There are always outliers, and Judge Cannon has humiliated herself, and it does seem to be the aberration here, doesn't she?
I mean, that's judging by the record of the court and the 11th Circuit and now the Supreme Court. And you're absolutely right. You know, this is Trump also lost, remember, in the Supreme Court on his taxes and on the election appeals. So it's a pretty consistent record.
Okay, so Jackie Alemany, to sum up, first of all, on the point you made about phone records, I often saw and heard that Donald Trump used other people's phones. So I wonder what you think of that. And then, is this the last hearing? Do we expect more? What are next steps, especially in terms of the Trump subpoena and time running out?
So next steps are they've got to put the paperwork together to actually get that subpoena to the former president. Then there's going to be ostensibly a deadline for him to respond to them. It's a very good question about whether or not he was using other people's cell phones. We do know that the committee, though, has subpoenaed other people for their phone records, bank accounts. They have really done an extensive job. This may or may not be the last hearing. I think there could be another one potentially that will reveal the highlights of the final report. But that probably won't come until after midterms. But look, the committee right now, they're losing staff. Lawyers are transitioning to new jobs. They are slowly winding down. That is the reality, but they do have a big task ahead of them. They've got to write this thing. They do have a few assigned writers on the committee who are charged with that, and different lawmakers are in charge of their various sections. But Trump could completely change the script if he decides to cooperate in some way, which is highly unlikely. But there are new documents that could be coming in. The National Archives could happen to stumble upon something new, deliver it to the committee. Maybe Secret Service hands over more. Maybe they re-interview Tony Ornato, Bobby Engel. There's always a wild card here with this committee. They do a very good job of keeping some surprises.
All right, Jackie Alemany and Ken Dilanian, thank you both very much for your reporting and analysis. We appreciate it. And